I can't tell you how many times I'm told by criminal defendants, the police didn't read me my Miranda rights. Does that mean my case will go away? In this video, I'll give a very basic explanation of the Miranda warning, where it came from, and when it can apply to help a criminally accused person. My name's Amanda Bynum. I'm a criminal defense attorney and the owner of AJB Law Firm in Tucson, Arizona. This video is meant to be an educational resource for people accused of a crime or those who are just curious about how Miranda is used in practice. Nothing in this video should be construed as personal legal advice. If you have been accused of a crime, it's important that you speak with your own attorney who is familiar with the facts and circumstances in your case. Let's start with a quick review of what the Miranda warning requires. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you? With these rights in mind, do you wish to speak to me? Remember, the question that I get asked by defendants all the time is whether a failure to read Miranda warnings will result in their case getting dismissed. To that, I always refer them back to the Miranda warning itself. It deals with only statements made by criminally accused people that the government wants to use against them. If a criminally accused person gives incriminating statements to the police, an experienced criminal defense attorney will look closely at the facts and circumstances surrounding the situation in which the statement was given to determine whether a constitutional or Miranda challenge is appropriate. Before I explain the circumstances under which a Miranda violation can be helpful to a criminally accused person, let's go back in history to where the Miranda warning came from. Miranda warnings are named after a 1966 Supreme Court case that actually arose out of Arizona. It involved 24-year-old Ernesto Miranda, who had been accused of some very serious crimes. He was in police custody and questioned for 2 hours before finally admitting to the crimes that he was accused of. At the end of giving those statements, he even signed a piece of paper that said that he understood his rights. Still, Ernesto Miranda's lawyers challenged the admissibility of these statements. You see, this was at a time when police interrogation tactics were shady at best. They were done in private without lawyers present and were known to perpetuate police brutality, false and coerced confessions. So, Ernesto Miranda's lawyers challenged the admissibility of his confession in his trial because Ernesto had not been advised of his right to have an attorney present during questioning and his right against self-incrimination. After he was convicted, Ernesto Miranda's lawyers appealed the admission of his statements to the Arizona Supreme Court, who held that the statements were properly admitted at his trial. After that, the ACLU got involved and the case was appealed all the way to the United States Supreme Court. In a 5-4 ruling, the Supreme Court reversed the Arizona ruling and found that the statement was inadmissible and could not be used against him in his trial. After this decision, if a criminally accused person makes an incriminating statement that they allege has been made in violation of the Miranda warning, the court will look to 3 factors: whether the person was in custody, whether the person was questioned, and whether that questioning was by the police. So first, the custody question. What does that mean? It's based on a reasonable person standard and whether or not a reasonable person would feel free to leave under the circumstances. So what would a reasonable person think if they're in handcuffs in the back of a police cruiser? A reasonable person would believe they're in custody. However, if a person is standing on the sidewalk and the police approaches them and asks questions, there's no indication of authority, they're not in handcuffs, they're pretty much free to leave, then that person is not in custody. Second, the question is whether the person was questioned. So this means that the police actually have to be interrogating and asking the person questions about the crime. It doesn't count if a person, for example, is sitting in the back of a police car and is just making admissions about crimes. In that circumstance, Miranda would not apply because there's no questioning that's taking place. Third, the questioning and the custody has to be a result of police. So if a private person for some reason was holding and questioning a criminally accused, Miranda does not apply. When a statement is challenged, the court will look at all of the circumstances surrounding that statement to determine whether a Miranda violation occurred. If the court does find that the statement was taken in violation of Miranda, the remedy is that the statement cannot be used against the criminally accused person at a trial. But the police can still use all of the other lawfully obtained evidence in a trial against the individual. What this means is that the entire case doesn't go away, only the statement would be suppressed. And if the criminally accused chooses to testify at a trial, the prosecution may still be able to use statements taken in violation of Miranda for impeachment purposes, or to show the jury or the finder of fact that the defendant is not being truthful. So all of this to say that Miranda warnings only apply to statements given by criminally accused individuals when they are in custody and subject to police questioning. And if those rights are violated, then that statement cannot be used against them at the trial. However, all other lawfully obtained evidence can. And if you're curious about what happened to young Ernesto Miranda, after the Supreme Court decision, the case was actually sent back down to the trial court where Ernesto Miranda had a second trial. In that trial, the government was not able to use his confession against him. However, they had developed more witness testimony that eventually resulted in a conviction. Ernesto Miranda spent years in prison before eventually being released. Interestingly, he was killed not long after his release in a bar fight. 2 people were suspected of his murder. When police questioned them about the crime, each of the suspects were read the Miranda warning named after Ernesto Miranda. I'm Amanda Bynum. I'm a criminal defense attorney in Tucson, Arizona. I own AJB Law Firm, LLC, where we represent individuals accused of misdemeanor and felonies within the state of Arizona.